All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Mr. Court Officer, please call the case.
Good afternoon, Your Honors. This is the file number KCBC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krsnici. Thank you, Your Honors.
For the record, I note that Mr. Krsnici is present in court with us today. Mr. Thaçi, Mr. Veseli, and Mr. Selimi waived their right to be present in the courtroom today and instead are appearing via video conference. Before we start with the agenda of today's status conference, there are some preliminary matters that the panel would like to address. First, the panel recalls that at yesterday's hearing, the SPO tendered for admission two documents, SPO E0405847-00405880 and DHT 10293 to DHT 10336, which the panel marked for identification as MFI P04515 and P04516, respectively. The Thaçi defense objected to their admission, arguing that the documents constitute written statements given by IDW-007 as a witness under oath before the United States Armed Services Committee, and as such they are testimonial in nature and were given in relation to legal proceedings. The SPO in turn replied that the concerned MFIs are not subject to rules 153 to 155 as they are not statements taken as a part of criminal or civil proceedings. This is at page 14 to 15 and 56 to 58 of yesterday's live transcript. As previously reiterated by this panel, Rules 153 and 155 are legis specialis in respect of evidence that comes within the scope of the notion of a written statement given by a witness. See, for example, F01852, paragraph 10. Where proposed evidence qualifies as a statement, it must therefore be offered pursuant to one of those rules, so as to ensure that a party cannot circumvent the particular safeguards provided for the admission of witness evidence. The panel observes that Rules 153 to 155 do not limit their scope to written statements given by statements in the context of a criminal investigation or criminal proceedings. For the purpose of Rules 153 to 155, it suffices that the concerned statement is testimonial in nature and was given in relation to legal proceedings. In this regard, the panel directs the parties to its oral order of 23 September 2025. In this instance, the proposed items do not constitute written statements of a witness in the context of legal proceedings. Both MFIs are a transcript of hearings of the United States Senate Armed Services Committee. The panel considers that hearings before the committees of the United States Senate of the type described in the relevant MFIs are not legal proceedings for the purpose of Rule 153 to 155 as they are not meant to resolve a legal dispute through a judicial process. The fact that statements may or may not have been given under oath is not material. There is also no indication that these statements were taken in anticipation of legal proceedings, whether civil or criminal. The panel notes that it has previously admitted into evidence under Rule 138 similar records from hearings of the Assembly of the Republic of Kosovo and the United States Senate as tendered by both the SPO and the Thaçi defense. These are P00942 and 1D00290. For the reasons described Above, the panel finds that the MFIs P04515 and P04516 are not distinct from those prior admitted records. Such an approach is also entirely consistent with that of other jurisdictions with a comparable evidential regime. For instance, in the Cartesic case before the ICTY, various statements made in Parliament were admitted as exhibits in that case. Accordingly, the panel finds that MFIs P04515 and P04516 do not fall within the definition of statements within the meaning of Rules 153 and 155, or 153 through 155. The panel also finds that MFIs P04515 and P04516 meet the requirements for admission under Rule 138. They are therefore admitted. This concludes the panel's first oral order. Second, on 8 September 2025, the SPO requested that the panel consolidate prosecution exhibits P00074, P00507, P01634, and P02619, which are all portions of U000-8, U0004844-U0004859 into one single exhibit. The SPO outlined that it had engaged in inter-parties correspondence with the defense and that there is no objection to this proposal as long as all pages of U000-4844 to U000-4859 are included in the consolidated exhibit, including those not previously admitted. Can I confirm that there are no objections to all pages of U000-4844 to U000-4859 being admitted into evidence?
Your Honours, no. It was our proposal to include the full range, so we are hoping that that will be agreed and so ordered.
Thank you, Mr. Dixon. Victims' Counsel, any objection?
No objection, Your Honor.
Having heard the parties and participants, the panel admits into evidence the pages of U000-4844 to U000-4859 not previously admitted into evidence and any corresponding translations, and directs the registry to merge P00074, P00507, P01634, P02619, and the additional pages just admitted into one consolidated exhibit, namely P00074. This concludes as the panel's second oral order. We will now proceed with the agenda of the status conference. The panel scheduled this status conference in order to facilitate the close of the evidentiary proceedings. The panel would like to discuss the following topics: reparation proceedings, the close of the defense case, and evidentiary proceedings, agreed facts, transcript reclassification, rebuttal and rejoinder evidence, and finally, final trial briefs and closing arguments. Regarding the first point on the agenda, and by the way, please consider this a discussion. I don't intend to do all the talking. We want to hear everyone's thoughts on these subjects. We will make a decision, hopefully, yet this week after today's hearing. So first, concerning the first point on the agenda, the panel notes that the parties and participants filed their submissions on the modalities for reparations proceedings on Monday, 17 November 2025. The panel notes that the SBO indicated in their response, that is, filing F03582, that it is available to make submissions on, number one, whether the panel shall refer victims to civil litigation in Kosovo pursuant to Article 22, Paragraph 9 and Rule 167, or issue a reparation order pursuant to Articles 2.2, paragraph 8, and 4.4, paragraph 6. And 2, the time required by the SBO to respond to a request for reparations filed by victims. Counsel, according to the schedule deemed appropriate by the panel, Madam, or Mr. Prosecutor, are you ready to make them now?
Yes, Your Honor, and we can be brief. We support Victims' Council submissions, and those are F03583 in relation to not referring victims to civil litigation in Kosovo. And the reasons are the ones enunciated in Victims' Council submissions, primarily the issue of protective measures and also the issue of the location of the victims in this case. Sorry, I think I forgot your second question.
You forgot the second part.
Yes, as to when the SBO would respond to requests for reparations filed by Victims' Council, we would be able to do so whenever your judges decide. We would request the same deadline afforded to the defense in that regard.
Thank you. The panel will now like to invite submissions from the defense as to whether the panel should refer victims to civil litigation in Kosovo pursuant to those articles already named, or issue a reparation order pursuant to Article 22.8 and 44.6. You in a position to make those submissions now?
Thank you, Your Honours. On behalf of the defence, as set out in our submissions, we submit that it's premature to make those particular submissions now. We agree with the Victims' Council that reparations should be done after the judgment, and it couldn't be set out better than has been done so by Mr. Laws in his filing, that the possible permutations are endless. We don't know what the findings are, which victims may be included or not. It might be that for some, if they are included, that it's appropriate to go to Kosovo, for others not. And it's possible to have both a reparations order and referral. So our submission is we have to wait until then to do it. That's the appropriate time to do so. Certainly a wholesale blanket rejection of the national jurisdiction is, at this stage, premature, we say, and unfair, particularly when the court is there to assist the national jurisdiction. But we're getting ahead of ourselves. We say we ask that be done at the appropriate time. We would ask for 4 weeks to respond to any applications made and submissions made on reparations by the victims. We would say after the judgment, Mr. Laws has proposed 4 weeks, and then we want a further 4 weeks to respond after the judgment when it's known what the findings actually are.
Anybody else?
Your Honour, can I simply add that we understand from filing F3583 that one of the key issues is going to be the availability of protective measures in national proceedings. And I'm just not in a position to be able to assist on the detail of that today. And we would wish, if the panel is minded to make an order, that we have some time to consider that point. Noting that in the Schaller case, filing, I think, 310, that was addressed on the basis of the expert evidence available in that case, the defence choosing not to make submissions on it, and that filing then being followed in the subsequent Schaller case. So it's that we would wish to look into specifically before trying to assist further.
May I reply to Mr. Dixon, please, briefly? 2 points. First of all, we submit it's never going to be appropriate to refer any of the victims in this case to Kosovo, and so waiting to see the outcome and whichever one of the many permutations that could possibly arise, it simply isn't a relevant consideration. We've set out all the reasons why it's not going to be appropriate, and those are going to apply at any stage of the case and in respect of any factual findings. The second thing that I would like to say is that the decision needs to be taken now. The victims and we need to know what the future holds, and the defence have had adequate notice of this. The submission that they should be allowed to wait until the judgment is, we respectfully submit, misconceived. That should happen this week with the other matters that are going to be decided in relation to today's hearing.
Thank you.
If I can reply briefly, I mean, that's an entirely abstract decision that would be made, whether or not there's going to be a reparations order or referral or both. It can only be done based on the victims we are talking about when particular findings are made, if they are made, and then taking into account what are the possibilities within the national jurisdiction to make full submissions then. With the greatest respect, the victims don't need to know now. They have to wait for the judgment anyway. And then the various courses can be looked at the appropriate time with full submissions.
Panel wish to have any questions about this? Yes.
Yeah, thank you very much, Judge Smith. Mr. Laws, I have 3 points I'd like to raise. With you, in your filing of paragraph 23, you refer to the 3 expert reports from Dr. Lertz, which are referred to in paragraph 7 above.
Yes.
Those are the 3 expert reports you already submitted, and their admission was denied without prejudice.
That's right.
So you don't, my question is, why do you need 2 weeks to submit them? We already know what they are.
The straightforward answer to that is that, first of all, in respect of the Lertz report in relation to this case, it's likely to be in a somewhat different form to the one that was submitted. We want to change it, and we want an opportunity just to ensure that it is properly aligned with the factual findings in the judgment.
My second point concerns your proposal to engage an expert to report about possible forms of collective reparations.
Yes.
And you indicate in your filing, paragraph 34(3), that work on a possible proposal for collective reparations based on the expert report. You've had preliminary discussions with relevant experts.
Yes.
Now, I was wondering if you could help me on one thing, and that is your victims obviously will be able to express to you whatever preferences they have on the
Yes.
issue of individual versus collective reparations, on what kind of collective reparations, if there is any conviction in this case. You and your team in turn have all the expertise you need to make submissions to the court reflecting the preferences of the victims. So my question is this: what added value does an expert witness bring? How can the expert witness add to the court's understanding of what you will be presenting on behalf of your clients?
Well, it's not so much adding to the court's understanding, but giving an opinion about what might be a practical and useful mode of collective reparations. And the experts that we have spoken to, some of them are people who have in the past made proposals which have then been adopted in relation to collective reparations. And it's not collective reparations or individual reparations. It's something in addition to individual reparations.
I'm just wondering if it's necessary to wait for an expert report. If you could pick up whatever great ideas they might have, they could inform your submissions directly to the chamber, and we wouldn't have to have a delay in time in order for those reports to be filed.
Yes, and I see Your Honour's point with respect, but generally speaking, when a proposal of that kind is made, it probably has more authority coming from an expert than from counsel. So perhaps we can wait and see what emerges from it.
Yes. The final point is the expert evidence, you say, in paragraph 26, is limited to the Lertz reports plus this report that we're
Yes.
talking about, a collective.
Yes.
I want to clarify whether you intend to submit non-expert evidence of any kind.
We deal with that possibility, Your Honour, if you give me just a moment. We deal with the possibility of submitting evidence from the victims themselves, depending on the outcome of the request for partial consideration that we've made of our Rule 153 application. And we need to see the outcome of that, and then we'll look again at whether or not there's scope to submit further non-expert evidence in the shape of the victims themselves. And that's at our paragraph 25 in our filing under the heading Other Material.
I understand. Finally, there's been reference in submissions both by the defence and by you as to the difficulty of making submissions when you don't know what, if any, convictions might be entered.
Yes.
In respect of which victims. Would you agree that there are, broadly speaking, submissions that can be made working on the theoretical assumption that some convictions might be entered, even if you're not able to make totally tailor-made submissions? Would you agree that there are submissions that could be made prior to knowing if any conviction is going to be entered?
Well, we would need to make submissions covering every factual finding that could arise in order to make meaningful submissions. Yes, such submissions could be made in theory, but in practice, it would be a very, very sizable task to look at the liability of each accused with every permutation across every detention site or family affected by murder, and to try to say for each permutation what the outcome should be. I mean, we regard that as being something that we won't be able to do in a manner that's useful to the panel.
Okay, thank you very much.
Mr. Laws, one other thing. You've indicated that you do not believe it would be possible to make the referral to civil authorities in Kosovo.
Yes.
Could you tell us why that is? And we can be in private session if you need, if there's something sensitive about it. But I just would like to have your reasoning stated on the record.
Yes. Well, thank you very much for the opportunity, Your Honour. We have provided, as the court knows, detailed written submissions in respect of this topic, and our submissions were almost entirely dependent on the findings of Trial Panel 1, who considered exactly this question in both the Mustafa and the Shala cases. And they instructed 3 experts with relevant expertise in relation to civil litigation in Kosovo in order to assess whether or not such a referral would be practical. And the result was a very clear one, and it's dealt with at our paragraph 13 of our submissions, but citing it more extensively than I could repeat here. Trial Panel 1's analysis of the position, first of all, in relation to the availability of anonymity for victims in civil proceedings in Kosovo. And the headline in relation to that topic is that civil proceedings in Kosovo don't provide for anonymity, and that therefore the victims who were concerned in the litigation would need to disclose their identity with all of the difficulties that entails. And so their conclusion, and I will read just this part as I'm given the floor, at our paragraph 14, in light of the foregoing, the panel considers that it would not be appropriate to refer victims to civil litigation in Kosovo courts pursuant to Article 22.9 of the law and Rule 167 of the rules. That was their conclusion based on anonymity. It actually, the issue goes significantly further than that, because the anonymity issue alone was enough for them to deal with this issue in both Mustafa and Shala, but the experts highlighted significant further difficulties in the way of victims seeking justice in the civil courts of Kosovo, and those included the likely, and this is our paragraph 18, the likely existence of a certain level of corruption and interference within the Kosovo legal system, the length of civil proceedings, potential problems concerning the execution of awards issued by Kosovo courts against assets located in the territory of a country which lacks judicial cooperation agreements or diplomatic ties with Kosovo, the fact that existing funds for the provision of legal aid may not have sufficient resources to ensure that legal aid is continuously provided, and finally, uncertainty with regard to the application of statutes of limitations, if any, to civil claims advanced by victims of war crimes. That's what the experts told Trial Panel 1, and we submit that in addition to anonymity, which is enough, we say, to end the debate, those are also highly relevant features to bear in mind. The principal difference in terms of this case and the Mustafa and Shala cases is the demographic of the victims. In particular, a large number of the victims in this case no longer live in Kosovo, and as well as all the additional obstacles that we have just looked at, that the experts identified, for those victims, we submit that it's really quite impossible to see how they could be expected to access justice in Kosovo at all. But that is an additional argument. It's not the main argument that we put forward, but it relates to a sizable number of the victims concerned, and so we set it before Your Honour. Does that answer Your Honour's question?
Yes, it does. Thank you. It's very, very helpful.
Your Honour, if I may respond briefly, I mean, that highlights exactly the point the defence is making, that we potentially need expert evidence to respond to that. I mean, the idea that the entire national jurisdiction just gets thrown down the drain is both extreme but premature
Mr. Dixon,
well.
we've already had professional experts. You just heard about them.
Yes,
they were in a different case, but it was the same issues.
But there might well be a different perspective, which is saying that the system can allow for
That may be
heard.
worth an argument, but I don't know that it's very
Well,
convincing.
Your Honour, I don't know of a national jurisdiction that allows a totally anonymous civil claim ever to be brought. Perhaps Mr. Laws can enlighten us. There are ways of dealing with sensitivities in every national jurisdiction, and they might well exist in Kosovo. I just think it's unfair at this point to say the entire system is a waste of time and corrupt without hearing a full, balanced account of this. And there might well need to be evidence on that.
I think you've made your same point 3 times, so thank you very much.
May I just reply to it? We're not talking about a comparison between Kosovo and other national jurisdictions that may equally have or not have scope for anonymity. We're talking about a comparison between Kosovo and this court, which does have the power to safeguard the anonymity of the victim. So the comparison is entirely misplaced. And I emphasize that what I have read is not the opinion of Trial Panel 1 or judges here. It's not my opinion. It's the opinion of independent experts who were instructed to look at this issue, not 1, not 2, but 3 of them. And that was the conclusion that they reached.
Thank you. Are there any other outstanding or further matters the parties and participants would like to raise in relation to the reparation proceedings? Nothing seen. Thank you very much. Next, the panel would like to explore with the Thaçi defense and the Krasniqi defense further steps that need to be taken in relation to the closing of their defense cases. Witness 1DW007 finished his testimony yesterday, that is 18 November 2025, as the last scheduled witness of the Thaçi defense. In light of this, the panel wishes to confirm with the Thaçi defense and the Krasniqi defense that they are in a position to close their respective cases soon. To this end, can the relevant defense teams confirm on the record that they have no further witnesses to call and indicate whether they have any further motions to file for the admission of evidence? If there are other further motions to be filed, it would be helpful for the defense to indicate an expected timeline for the filing of such motions. Mr. Mistich, you may go first.
Yes, Mr. President. At the moment, we do not have any additional witnesses. However, we do have a pending Rule 153 motion. Depending on the outcome of that motion, we may wish to call W04752 as an additional live witness, depending on how you resolve the Rule 153 motion. With respect to written evidence, we don't currently anticipate offering additional evidence. However, we would like an opportunity to go through what's left of the exhibits on our exhibit list. If anything, it would be less than a handful of exhibits. We would contact the other parties to seek agreement or their comments, and we would file any motion along with a justification pursuant to the trial panel's earlier order that we would need to demonstrate good cause for the additional motion, and we propose to do that a week from today by next Wednesday.
That is sufficient. I can tell you, we planning on for the date to close everything out in about 2 weeks.
Yes,
So that will give you ample time to do that. We intend to have questions answered, written filings answered by December 1st. So just to give some people a guideline.
Yes. So in answer to the question of when we would be prepared to close our case, like the prosecution, if there's a bar table motion, we could still close and let you resolve the bar table motion. The only issue we have is with respect to W04752, which would prevent us from closing until that issue is resolved.
Understood that.
Thank you.
Thank you. Mr. Ellis?
We don't anticipate filing anything further at this stage. If we might have a day or two just to review our exhibit list and confirm that, but
You've heard my statement. Let's just say you have a week to make that decision, and
I'm grateful.
so that we can then act on it. SPO or Victims Council have any submissions on this particular issue? No? Okay. Taking into consideration the submissions just made, are the Thaçi defense and Krasniqi defense in a position to indicate a particular date when notification for the closing of their case will be filed?
At this point, I can just say shortly after resolution of the issue of W04752. So if it turns out we have to call them live, then it's up in the air as when we would close. If there's a ruling on the motion, we could close shortly thereafter.
All right, so, okay, that's fine. Mr. Ellis, anything?
for us, I think it would be the deadline just mentioned, so a week from today.
A week from today.
Earlier, if we can do it.
That's certainly sufficient.
Okay.
Thank you. Next, the panel wishes to move to a slightly different matter, which is agreed facts. The panel observes that on the last report concerning agreed facts was filed by the SPO on 13 September 2024. That is filing F02573. The panel seeks confirmation from the parties and the participants as to whether there are any outstanding or pending inter-party discussions in relation to agreed facts and whether F02573 is in fact the last intended report on this matter. We'll start with the SPO.
Thank you, Your Honor. There's no outstanding conversations about this to our knowledge, and yes, we confirm that F02573 is the last report on the matter.
We agree with that submission.
Nothing to add, Your
Now, in relation to transcript reclassifications, the panel notes that there are a number of transcript reclassification requests pending before the panel. The panel would like to hear from the parties and participants whether they have any objection to evidentiary proceedings closing while the transcript reclassification requests are pending. Once again, we'll start with the SPO.
We have no objection to that, Your Honor.
We have no objection to that, although I have one point to add. I don't know if you want me to do it now. Your Honors, we have to alert the tribunal that unfortunately we did not pursuant to this panel's earlier order about making public redacted versions of transcripts for the September block of witnesses, we unfortunately did not undertake that process. While most of the hearings, as you know, were in public session anyway, and we don't anticipate any significant redactions to the transcript being required. We would like an extension of time of 1 week to go back and look at the September transcripts. With respect to the November transcripts, we will go ahead and make sure that that's done.
A week from tomorrow.
That's fine.
Is that sufficient?
Yes, that's sufficient. Thank you, Mr. President.
Mr. Dixon, anything?
No objections, Your Honour. Thank you.
Mr. Roberts?
No objection.
Mr. Ellis?
No objection, Your Honour.
Noting that the panel will not call any evidence pursuant to Rule 132 and without prejudice to the procedure set out in Rule 133, the panel inquires whether the SPO could provide an indication of whether it intends to seek leave to present evidence in rebuttal, and if so, whether the defense could provide an indication as to whether it intends to seek leave to present evidence in rejoinder. Mr. Potch.
Thank you, Your Honour. Having considered the applicable standard under Rule 133 and this court's jurisprudence on the matter, and in view of the fact that decisions on the admission of evidence, as you have acknowledged in this case, remain pending, there is also no final decision by the Thaçi and Krasniqi defense as to whether or not they'll be filing any further motions. We just learned that we will know that next week. At this stage, the SPO is considering whether it will file a motion under Rule 133, but it has not reached a final decision in that regard. And of course, as can be expected, whether or not we do file such a motion is largely dependent on the outcome of currently pending defense requests for the admission of evidence. But at this stage, we can already say that any Rule 133 request would be limited in scope, and we would not be requesting that any further witnesses be called to testify live or pursuant to Rule 154. And in terms of timing, if that assists, we anticipate we would be able to file a request or to notify you that we will not be filing a request within 1 week of any final decision on the admission of evidence tendered by the defense.
Go ahead.
All I can say at this point is we obviously can't tell you whether we wish to file evidence in rejoinder until we see what the evidence in rejoinder until we see what evidence would be submitted in rebuttal.
We will expect you to have that decision in hand, maybe not issued, but in hand, so that when we rule, we immediately get a response. In other words, it might be a week from now and be ready to respond immediately.
Yes, of course, it depends on what immediately means, because, as I mentioned, our rebuttal request would depend on what you admit.
I know, but
we already have things in mind. If you admit this, we'll do that.
We will have those by December 1st, and you will need to be in a position to respond by the 2nd.
That's a very tight deadline, but we'll
That's a
make
very
any
tight
request for
deadline.
extensions if we need it.
At this point, everything is going to be a tight deadline, so you might as well get used to it. All right? We'll now move to the issue of closing of the evidentiary proceedings. The panel anticipates issuing decisions on all currently pending evidentiary decisions on or about 1 December 2025. The panel wishes to inquire whether there are any other issues that the parties and participants anticipate, and I'm asking for direct answers, not wishy-washy answers. I'd like to have a direct answer on these matters. Are there any other issues that the parties and participants anticipate which would preclude the panel from closing evidentiary proceedings on or about 4 December 2025? And in addition, do the parties and participants have any objection to the panel closing the evidentiary proceedings in writing rather than in a hearing? And we'll start again with the SPO.
As to closing in writing, we have no objection, and in terms of issues that would preclude it from closing on 4 December, that of course depends on when the panel issues a decision and whether or not the defense is going to present any further motions, which we'll learn next week, but otherwise we can't think of anything at the moment.
Thank you.
So I don't anticipate any motions by the defense, additional motions that would preclude you from closing, meaning if we submit something for a bar table, that shouldn't preclude you from closing. The pending Rule 153 motion could, because if, depending on its outcome, we may have to call them, and I don't see how we could get that done before the 4th of December. And then third, depending on if they file a motion for rebuttal evidence, then you can't close because we may also then wish to file rejoinder. So other than that, I don't see any other issues.
And number 4, Mr. Michetic, about closing in writing. Any?
Yes, we have no objection of doing that in writing. Yep.
No objection to closing in writing either, and nothing foreseen. I simply flag up, Your Honours, not that we are going to take any steps. Of course, it may be open to Your Honours still, but there was a registry submission. It was confidential, so I'm just going to refer to it in general, regarding a request for assistance to a third state where a report was given about non-cooperation. That's F03586. That report has been submitted. We are not taking any further action because it seems the matter is final, but simply to flag that up if there was anything arising from Your Honour's side.
Thank you.
Thank you.
Mr. Roberts.
No issues and no objection to notifying in writing.
We would support closing in writing, and we have no new issues beyond those discussed already.
Thank you. Your Honour, we have one filing that we will be making. It's not an evidentiary filing, so it doesn't necessarily affect the topic of the closing, but we thought it appropriate, just out of courtesy, to inform the panel that we will be submitting an additional filing which relates to the scope of admission in relation to a number of victims in the case. We can't submit that filing until there's a decision in relation to our request for reconsideration in respect of our Rule 153 application, but we will be doing so very soon after the decision is issued.
Thank you for the heads up. We'll now move to the last point of today's agenda, at least the last one that I have. On 13 October 2025, following inter-party consultations with the parties and the participants, the Thaçi defense, 1, requested that the parties' final trial brief be submitted on 30 January 2026 or 60 days after the closing of evidentiary proceedings, whichever is later, and 2, noted that while Victims' Counsel did not join this request, he did not oppose a reasonable proposal for a new deadline that does not affect the expeditious conclusion of these proceedings. Now that the last witness of the defense case has testified, or at least what we are now assuming will be the last one, knowing that there is one possibility left, and in light of the submissions heard during today's status conference, the panel wishes to hear from the parties and participants as to when they envision that they will be in a position to file their final trial briefs or the impact statement, as the case may be, beginning with the SBO.
Yes, as previously communicated, the SBO joins the request for a 30 January 2026 deadline, or a deadline 60 days after the close of evidentiary proceedings pursuant to 134, whichever is later. The joint request is reasonable. Throughout the trial, evidence has been admitted and issues resolved on the understanding that the parties and participants would have the opportunity to make submissions on ultimate weight and present their respective cases on the basis of the evidentiary record as a whole at the close of the trial. Final briefs provide that opportunity. They're an important phase of the trial and of the adversarial process, particularly in circumstances of a case of the size and complexity as the one we're dealing with. While, of course, parties and participants are expected to work on and progress their briefs over the course of the trial, adequate time should be given after the close of evidentiary proceedings to focus on final submissions. Considering that, at earlier phases, resources are necessarily diverted, and naturally, the evidence as a whole cannot be adequately assessed and final positions taken until the presentation of evidence is complete. In this respect, earlier this year, the presiding judge indicated that a certain degree of latitude would be available in relation to timing of final briefing, and that's from the 19 February transcript. The reasonable nature of the joint request, which is agreed to by all parties, and that should have some weight in and of itself, is also evidenced by the fact that in the other cases before this court, which everyone here will agree with are a fraction in terms of scope and complexity of the case we're in today, in those cases, in two of those cases, the parties got a 30-day minimum, which is prescribed in the rules, and in another case, they got 45. Amongst the other factors evidencing the reasonable nature of this joint request are that the indictment spans 1.5 years, the charges concern 10 counts of war crimes and crimes against humanity at locations across Kosovo and parts of Albania, with over 400 alleged incidents of detention and over 100 alleged victims of murder or killing. The evidence of over 250 witnesses has been heard or otherwise admitted. Over 5,000 items of evidence have been admitted into evidence, and decisions on over 300 tendered items remain outstanding. Other than being reasonable, the request is also realistic. Evidentiary matters and related litigation continue. We now know that the defense has 1 week to inform the panel whether any further requests will be made, and we learned yesterday of the panel's intention to issue any pending decisions by the 1st of December. And it's also realistic to understand that depending on the outcome of those decisions, even if by 1st December, one party or another may, for example, seek leave to appeal. The panel must also give the SPO adequate opportunity to file any motions for rebuttal evidence. I drafted this before Your Honour told us that we would have to do so immediately, within 1 day, but I reiterate our request and we'll see how that goes. And in this context, bearing in mind where we're at now in the trial, the intention, the panel notified on the 2nd of September of this year to set a deadline for final briefs before the commencement of judicial recess, which would be Friday, 19 December, is not realistic any longer. And in terms of setting a realistic deadline, we also asked the panel to consider the pace at which the proceedings have progressed to date. The SPO called over 120 of its witnesses between April 2023 and April 2025. The victim's case opened in July 2025, and the defense case opened in September of this year. At each of those stages, understandably and necessarily, resources were diverted to ensure that each phase of the process proceeds fairly and expeditiously. As soon as the ambitious target date for the SPO case was met, we focused resources on responding to a Rule 130 request, preparing for victims' counsel case, and then the defense case. And in terms of preparation for the defense case, it's not only the cross-examinations Your Honours have seen before you or the filings you have read in terms of our responses to defense requests. We also prepared extensively to cross-examine witnesses who were dropped shortly before their scheduled appearance, some of whom were particularly documentary heavy and required extensive preparations. And from our side, preparation for the defense case also meant responding to inter partes disclosure requests, which ultimately required our office to commit extensive resources to document review for multiple weeks and disclose over 300 items in response. And just to conclude, I will note that the panel will certainly appreciate that providing the parties the adequate time that is being jointly requested is in the interest of justice, including the interests of victims of the alleged crimes. And it's also in the panel's best interests in terms of ensuring that the best possible assistance to the panel is given when ultimately deliberating and reaching its judgment. Thank you.
Obviously, it's a joint proposal, so we join in much of what was said there. I would also add, specific to the Thaçi defenses, we have been very intensively working on the defense case thus far and simultaneously trying to do as much as we could to get ready for the final briefs, but there is no way that we could devote sufficient resources to assist the accused in assessing 25,865 pages of transcripts, 11,568 individual items of evidence that have been admitted, And as you have said, as the trial panel repeatedly, in admitting evidence that the accused would have time to comment on the weight that should be given to these evidence, to this evidence at the appropriate time. And I would submit to you that the accused, in fact, will not be given a sufficient time to be commenting on weight, particularly the Thaçi defense, if we only have 2 to 3 weeks from the close of the evidentiary phase of this case. So we would ask, the parties have jointly requested, that the deadline be the 30th of January. Thank you.
Thank you, Mr. Misitich. Mr. Dixon?
Yes, thank you, Your Honours. The parties, as Your Honours have previously directed, spent a lot of time going backwards and forwards to look at coming up with a joint common position in respect of timing, but also in respect of word count, which we may come to. So I do hope that has assisted, but these have been open, backward and forth discussions to look at a reasonable proposal to put to Your Honours as a joint position. So that's why we endorse it, and also echo once again Your Honours' own words where when we discussed this matter some time ago, I know we were talking about much longer periods than of 10 weeks. It was indicated that our minds can be put at rest, though those words were used, that there would be sufficient time after 2 years of trial to be able to address all of the myriad of matters that arise. And just to echo Mr. Misich's point as well, in respect of the amount of exhibits, documents running to hundreds of thousands of pages, almost every one of them has to be addressed in relation to what weight to give them and how they relate to each other. That just simply factually takes so much time. So we reiterate the requests that have been made and would urge us to look at it in that light. Thank you.
Thank you, Mr. Dixon.
I don't need to repeat, obviously, what's already been said. I think the fact that the prosecution and the defence have agreed to this over the course of an antagonistic trial, but a trial when we haven't always reached agreement, does show that it is a reasonable proposal in the circumstances. We have got to the stage at the end of this very long, very detailed and complex trial that we do need enough time to properly make submissions, and we need enough time to make effective and focused submissions that will assist Your Honours in coming to your judgment. So we've obviously not called evidence, but we have been in court. We have been preparing and reviewing evidence that's been called by other defence teams. We have been, to the extent we can, working on the final brief, but we do need a significant chunk of time now to focus on preparing that. And as I said, the deadline and the agreement that we've reached, at least with the prosecution, I would submit is entirely reasonable in the circumstances. Thank you.
Thank you, Mr. Roberts. Mr. Ellis?
Your Honours, I don't propose to repeat the submissions that have been made. We agree with them entirely and endorse them. The only additional factor affecting us is that, of course, as Your Honours know, we're drafting in English, but taking instructions in Albanian, and key sections of what we're drafting for the final brief will need to be translated by us for Mr. Krasniqi to give his instructions on them. And that, of course, takes some time. So we endorse the proposals made, Your Honours.
Thank you, Mr. Ellis. Panel further notes that on 7... oh, I'm sorry, Mr. Laws. I don't mean to ignore you.
No, thank you. May I just say, for the record, that we regard the applications made on behalf of the parties as being reasonable, and we therefore don't oppose them.
Thank you. The panel further notes that on 17 November 2025, the parties and participants requested an extension of the word limit for the final trial briefs and Victims' Counsel's impact statement. The parties requested that the SBO be granted 180,000 words and the defense teams be granted 90,000 words for each of their final trial briefs. Victims' Counsel requests that he be granted 90,000 words for the impact statement. In this regard, the panel emphasizes that the parties' final briefs should focus on core factual issues and disputed issues instead of discussions of undisputed or irrelevant matters, such as historical background, Serbian crimes, discussion of matters already decided, unduly lengthy procedural backgrounds. Final briefs will not be expected to address issues relating to potential reparations. The panel also encourages the parties to engage in inter-parties discussions with a view to identifying what is in dispute between the parties. Do the parties and participants wish to make any submissions on this matter? SPO, you may start.
Yes, Your Honour. Briefly, the reasons why we requested an extension of the word count overlap with the reasons I put forward for the extension in time for the filing of the brief itself. Just by way of context, I note that our pretrial brief was just under 90,000 words. A lot has transpired since we filed that, and it's logical that more extensive submissions are required at the close of the case. And we underline that we're fully aware that the length of the filing is in no way commensurate to its quality, but our request to be granted 180,000 words as a maximum, rather than the default 80,000, which is what would apply in this case, is justified considering the burden of proof which lays on us, and the relevant factors go into the case's complexity that I mentioned earlier. Thank you.
Thank you, Mr. Potch. Any comments from the defense?
Nothing from us.
Anything?
Nothing further. The agreement has been reached on a realistic assessment where we will cut it down to the core issues. I give a full undertaking in that regard and not go into any of the peripheral matters so that it assists you on as much as possible.
Thank you, Mr. Dixon. Mr. Roberts, anything to add?
Nothing to add now.
Mr. Ellis, anything?
Nothing new, Your Honour.
All right, we will take that under consideration and include it in our decision. I think I told you, but we will try to have this decision on file by Friday, close of business. Lastly, pursuant
Sorry,
to
Ron,
rule...
if we're leaving the issue of the impact statement's length, may I just say that our request at 90,000 words, there are 155 victims participating in the proceedings. If one takes out the part of the impact statement that's going to deal with the law and other miscellaneous issues, it's a few hundred words per victim is what it comes down to. So I just wanted to say that that's what shaped the size of our request.
Thank you, Mr. Laws. Sorry if I skipped you again.
Can I just ask Mr.
Yes.
Misitic, just to clarify one point, it's one figure you gave. You said that over 11,500, I think you said, items have been admitted in evidence. What exactly are you referring to there? Because the number of exhibits seems considerably lower than that.
Yes, it's all language versions would bring that number to 11,568.
Oh, so
Right,
you're-
so the true figure, if I might put it that way, is really 1/3 of that. Would you accept if...
I haven't done the
a third
math.
to a half,
Okay.
a third to a half.
Yeah, a third to a half, something like that. But nevertheless,
You're
it's still-
counting every single language version. I understand.
Yeah.
Thank you.
But there are also, I think, exhibits that have been admitted with multiple parts, if you like. So it would feature only as one P number, but there may be 10 or
Right.
more parts to it.
You're right about that, Mr. Ellis. There are complex exhibits.
The long story short, though, is 2.5 weeks to go through all of that and give a fair opportunity, as was indicated. There were numerous objections to admission, and the answer was frequently, you'll have time to argue, wait later.
Mr. Misitic, while you're on your feet, I have to say I'm a bit concerned by some of the submissions I've heard, and I just want to be sure that I understand them properly, that the work on the brief is not yet to start for anyone. We have spent under, I think, 20 days in court since the middle of April of this year, which is quite a few months. So I hope that my assumption is correct, that the work on the brief has started long ago, and that we are not in the process of starting that. Can I just get that reassurance from you and from any of your colleagues?
Well, I don't know why that is being directed at me specifically.
Just because you were on your feet, Mr.
Okay.
Misitic.
Of course, we have been working on it for quite some time. That still, as you know, I'll speak for our team alone, we had quite a lot of work on an expedited schedule enforced by the panel to get the defense case ready. That absorbs a significant amount of resources. We had some people, but not me, for example, focused on the final brief, working on it, because I'm working on the defense case. And we just happen to have case 12, so there's a diversion of resources to that. And that's the reality for us. I can't speak for the other teams, but I think that's a reasonable.
You are right that I should ask the
Yes.
other teams as well,
Thank you.
who've had either no case or no second case. So, Mr. Dixon, can I take it that the work is and has been well on the way for some time?
Yes, Your Honour, you can take it that the work has been ongoing for some time. It's a process of assessing as the evidence is heard, but then looking at accumulating it all together, cross-referencing, comparing, knowing what is coming in finally as well. But that has had to happen alongside preparing for defence witnesses, even if we're not calling them, and dealing with a whole range of other submissions as well, bar tables, reviewing everything, and everything else that goes along with running a trial, as I'm sure Your Honours know. So it's not like you can just take off 3 or 4 months to purely write the brief. It's done alongside a number of things, and we're really looking for a clear period now where nothing else is going to arise to bring it all together and make sure we can do justice to it for the accused, but also for the court as a whole and the interests of justice.
Mr. Roberts, anything?
No, but just to respond to Judge Matray's question, yes, we have been working on the brief alongside other obligations. But yes, as I believe I mentioned earlier, we've certainly been doing that alongside.
Mr. Ellis?
Yes, the work has started, and it is with an eye on what we have been able to do thus far, that I can say with confidence that we do not believe we are in a position to meet the provisional deadlines previously set by Your Honours being before Christmas. And it was with an eye on what we have been able to do already that we made the joint proposal for the dates that have been given. So I can say I know where we've got to, but I also know where we still have to go. And that is why we endorse the submissions already made.
And can I get the same reassurance from the SPO?
Yes, you can, and I do know that having spent 20 days in court since mid-April does not paint a fair or complete picture of the work that's been going on since then, which I've outlined before. And I also note that if we were only to be starting work on the final trial brief now, I assure you we'd be asking for far longer than 60 days from the closing of evidentiary proceedings, which truly is the really bare minimum of what we need to ensure that you receive a product of good quality, as we hope we have been providing thus far.
Thank you, Mr. Posh. Mr. Ellis, or I'm sorry, Mr. Laws, anything to add?
Yes, we've been working on the impact statement.
All right.
Judge Smith, I forgot to add one thing, and you should be alerted to it on the record. We were alerted yesterday or the day before yesterday in case 12 that the single judge wishes to commence trial on the 15th of December, which would also significantly impact our ability to be able to deliver a final brief to you. We will make submissions on that issue before the single judge, but of course, without knowing how he intends to resolve this problem for us, we have to alert you to this issue.
Thank you. We were aware. Lastly, pursuant to Rule 135, the panel wishes to inquire from the parties and participants as to whether they can indicate the anticipated length of closing arguments and when they would be in a position to make such arguments. Do the parties and participants have submissions on the matter? We need to kind of block this out some time in the future so that the courtroom is reserved, because as was just pointed out, there could be another case going on in this room. So we'll start once again with the SPO, the length of your final arguments and when to do them.
Thank you, Your Honour. Of course, this is all going to be preliminary in nature. We note Rule 134 refers to closing statements taking place within 21 days of the filing of the briefs. Considering the same factors I mentioned earlier as to the complexity of the case, and also, more crucially perhaps, considering that there will be no written responses to final trial briefs, we propose that holding closing arguments no sooner than 45 days from the filing of final trial briefs may be appropriate. 45 days there being, I would say, the bare minimum, and subject to, of course, close analysis of the content of the briefs and any unexpected arguments that could be addressed in there. Other cases before this court are not really comparable when it comes to measuring length and timing and that sort of thing, for the reasons I've also mentioned earlier. But I do know that in the Mustafa case, if I'm not mistaken, there was a 60-day gap between the filings of the briefs and the closing arguments. And I also know that, as counsel for Mr. Veseli has pointed out, and I refer to the same transcript of 19 February myself earlier today, the presiding judge had indeed earlier this year indicated that the parties would have reasonable time to absorb the final briefs before closing arguments. And in our submission, a minimum of 45 days would be reasonable at present, at least.
Thank you, Mr. Potch. Mr. Laws, do you want to weigh in on this at this point?
We'll support what the prosecution have just said.
Thank you.
Our position is really related to the date of the filing of the final briefs. So if we get more time to file final briefs, we're not committed to 45 days. We'd like some time to, obviously, sufficient time to be able to process the SPO brief and to be able to meaningfully respond to it in oral arguments. But at this point, I think our priority is to get sufficient time to file the written briefs. In terms of how much time, we would ask for one full hearing day for the Thaçi defense to make final oral submissions.
How long would it last?
Yes, it's good you didn't get it from me because Mr. Counsel went first and we actually would agree with what counsel said for the defense. We were envisioning that the prosecution would have 2 days, so 10 hours, and each defense team would get 1 day each, which is 5 hours. The other thing to consider is that traditionally, and we would also request in this case, there would be one last round. If there could be a reasonable break to allow us to reply, we would then ask for 4 hours for ourselves for our final submissions, and then an hour for each of the other teams.
So just Mr. Patch, on your schedule, we would not be sitting for the next 5 months. Do I get that right before we hear your final submissions?
So on the joint schedule that's being proposed for 60 days for the final trial brief would bring us to early February if all decisions are done by the first week of December. And after that, if we're going to go with the SPO's proposal for 45 days, then we'd be looking at, if I'm not mistaken, mid-April, mid-March or end of March for closing arguments.
So 5 months, give or take.
Mr. Patrick, can I just ask you there? The prosecution's final brief is the vehicle for the prosecution to make all of its final argument. The final oral statement should merely be limited to responding to whatever is the most important issues you want to respond to in the defense final briefs. I simply don't understand why you need so much time to prepare for the final oral statement, having already filed a very lengthy prosecution final brief. Could you just elucidate a little more clearly why so much time is necessary?
Certainly. I think it's important to start off from what we are guaranteed by the rules, which is 21 days. 21 days, and that has been applied even in other cases, which, as I said, are far less complex. That is the minimum. We're barely requesting double the minimum. As I also mentioned, we would not be filing any written responses to the defense's written briefs. You can also imagine that once the briefs are filed, we need time to review those. And by review, I don't mean casually or very quickly. We need to check that the assertions being made, as obviously the defense would be doing for our brief, and as they should, and is to be expected, are accurate. Checking accuracy in another party's brief takes time. We do that across 4 briefs for the defense. Coming up with the arguments takes time. We might not need the 10 hours I asked for closing arguments. That's at the maximum end of the scale. But in terms of preparation and going about this and discharging our obligations in good conscience, yes, that is a very realistic time frame. And it's also it's also commensurate with what has been granted in other cases to our knowledge. And again, I think we can just go off the fact that in Mustafa there were 60 days. Obviously, every case has its differences, but when you're considering a case of this nature, in our submissions, 45 days is reasonable. Of course, if things change depending on the briefs, if there is magically a lot of agreement on issues, then perhaps less time will be required. It doesn't look like that would be the case as things stand at the moment, though.
Thank you.
Mr. President, I just wanted to alert you to a personal issue. I have a prior commitment from the 13th to the 23rd of February, which I've alerted the case 12 on. But if that is something that can't be avoided by the panel, then I will reorganize myself. But I wanted to just alert you to that. Thank you.
I'm sorry, I wasn't on the record. We'll let you know by Friday on that.
Yes, Your Honours, our position is, as already said by Mr. Thaçi, that if there's an outer limit that you're working on for when the judgment is coming out, then working back, we would rather have more time to use within that period on the written briefs, because that sets out, as his Honour Judge Gaynor said, that sets out the primary position. So we'd rather have more time on that, which might then mean, depending on the time limits, a shorter time in between the two. Of course, we need enough time to then respond, but that could be narrowed if we were given more time to put down the primary submission in writing. And then we would also ask for 1 day for the defence for Mr. Vaseli, and an opportunity to reply to any reply afterwards as the rules permit. Thank you, Your Honours.
Similarly, Your Honour, I agree with my colleagues. It does depend on the date for the final brief, but obviously our position is the same, that we would require more time for that rather than more time for final arguments, and we would similarly request a day for submissions for ourselves. Thank you.
Mr. Ellis.
Yes, I think my submissions have been taken. I agree entirely with my colleagues for the defence. It is the time for the final brief that is our primary concern at the moment.
Thank you.
And I agree 1 day for defence submissions.
Thank you very much. The panel informs the parties and participants that in light of the matters discussed today, the panel intends to issue a written order, as I said, by the end of the week, this week, setting deadlines and providing directions to the parties and participants in relation to the length of the final trial briefs and the impact statement, the date of the filing of the final trial briefs and the impact statement, date of the closing arguments, and other residual matters that remain unresolved following the status conference. Before we conclude today, I want to make sure that I've at least let you bring up any additional matters that has not been mentioned.
2 brief matters, Mr. President, unless the SPO wants to go first. Okay. One is we alerted the panel earlier today to a translation of P189 and P765.1. We would ask leave to add that. That has been that is the official translation provided by the Language Services Unit.
Any objection to that, Mr. Prosecutor?
As long as it is only being added and not replacing the page at issue, we have no objection.
That's fine, as long as the addition is recognized that that's the
addition
official.
will be added.
Thank you. And then the second is, as we indicated to you on Monday, we have disclosed yesterday a public redacted version of the witness statement of General Clark, and we ask that for leave to add that public redacted version to the existing Exhibit 1D430.
Same question?
No objection.
Okay, it can be admitted.
That's all we have. Thank you.
Mr. Dixon?
Yes, thank you, Your Honours. I thought there might be an item on the agenda for sentencing submissions, because we have made a request in our filing on Monday for those to be dealt with separately after judgment and any conviction, subject to rules 162 and 164.
We don't intend to sentence him before the judgment.
But it's a question of when we make the submissions.
Yeah.
Our request is that those are done separately after the judgment, if there were any conviction, and there's a provision allowing a request to be made. So that has been included in our filing on Monday. So we'd ask that be addressed, because that might well affect also the timing and the length of the word count of any submissions. But we would say that the proper course is to do it afterwards and separately, in line with the way in which it's done now at the ICC, or the practice at the ICC. We'd ask that model be followed here, as there is an option for that to be done under the rules.
We understand your request.
Thank you, Your Honours.
On that point, Mr. Patch, I'm I might have missed it, but the prosecution didn't make submissions on bifurcated sentencing, did it,
We didn't
in your
have it
filing
on
of the
the
Monday,
agenda.
the 17th of November? Does the prosecution oppose the request for bifurcated sentencing proceedings?
We didn't make submissions because we didn't understand that we were specifically asked to, but I'm ready to set out our position now. And we also had inter-parties communication about it in anticipation of today's status conference. The prosecution's understanding is that, consistent with Rule 1596 and previous decisions of this court, sentencing is generally, unless there's an exceptional reason, to be addressed in the trial judgment. And the procedure under Rule 160 164 would not apply in this case. In fact, in Case 7, this panel noted that Rule 1596 makes it clear that parties should assume that the panel shall determine the appropriate sentence at the same time as the pronouncement of the trial judgment, and that in the diligent exercise of their responsibilities, counsel for the parties must have planned for and presented at trial all evidence they consider relevant to sentencing. So in our submissions, there's no reason at present why sentencing should not be dealt with in the trial judgment, with the party submissions being included in the final trial briefs. Of course, this is a matter we defer to the panel. If the panel, either once it receives those sentencing submissions in a final trial brief, or if the panel is minded not to request them to be included at this stage, we will adapt as necessary. In fact, I know that in one of the decisions I'm referring to in Case 7, which is from that case 553, paragraph 18, the panel had noted that the parties should make those submissions, and essentially, if anything changes, the panel could still decide to issue the judgment and then still provide the guidance on the next steps for sentencing. So ordering us to file our sentencing submissions now is not necessarily binding on the panel having to issue sentence at the same time as the judgment. As I said, we are flexible, and we will do as ordered, of course.
Anybody else want to weigh in on this particular issue? Doesn't appear so. Sorry, I didn't see you stand up.
Your Honour, it's not on this particular issue, but before we close, can I simply raise that as part of the defence closing submissions, we anticipate that Mr Kwasniczy may wish to speak for a portion of that. I just wanted to put that on notice at this point.
Thank you very much. I'm assuming that probably that goes for everybody.
Yes, Your Honours.
All right. Any other residual issues that have not been discussed? Thank you very much, everybody. It's been an interesting ride, and I think we all appreciate everybody's efforts to be collegial, and I can say it's not that tempers don't flare occasionally, but all in all, it's been an interesting and enlightening experience. And I appreciate everyone's efforts. We've prodded and pushed and shoved and made your lives miserable, I'm sure, at times, and that's probably going to continue, but we do appreciate it, and we think it was very important for getting this huge number of witnesses and this enormous amount of material admitted and established in very, very efficient time. So thank you all very much for your efforts. I at least appreciate it, and I'm sure the panel members do. We're adjourned.
All rise.